Now this is part 2 of the video how to file a case without an advocate. Now if you go to court for any case, whether it is a suit is a legal language again, or whether it is a petition, that is also legal language, or a complaint, both are all are one and the same. Technically there is a deep down there is a difference, but suit or petition or complaint are one and the same. So when I will address it as a suit because it is a much authentic legal language. If you want to file a suit in the court without an advocate, it should have 10 elements without fail. If these 10 elements are not there, your petition will be thrown out. Your plaint will be thrown out. First is, it should have the details of the plaintiff or the petitioner, whosoever is filing the case. The second is, it should have the details, elaborate details, name, address, occupation, age, and more details about the defendant. So there will be one plaintiff as a one party, and there will be another party called the defendant against whom you file a case. The details of the defendant are more important than the details of the plaintiff because notice must go to the defendant. Plaintiff comes and files the case, but defendant will be somewhere else. Notice must go. Summons must go. So the details of a defendant are more important than the details of the plaintiff. So that is the second element of a suit. The third element of a suit is the facts of the case, the story of the case. How defendant robbed your right, that is the right of the plaintiff. How defendant damaged the right of the plaintiff, or the respondent damaged the right of the petitioner. How he caused damage. Because without damage, you don't earn a right to enter the court premises. Remember, nobody can't just walk into the courts. There should be a right. You should earn a right, and you earn a right when someone robs your right. So you have to describe the facts, what happened exactly. And here the role of an advocate comes, because every fact, please note this point very carefully, whatever fact you state, you must prove. So what to inform the court, what not to inform the court, there the advocate talent comes. There will be some establishing facts. There will be some facts which needed to be proved. There shall be rights which are establishment rights, and rights which you must prove that you lost it. So there the knack and the technique of the advocate comes into play. Generally, if you consider me, whenever a client comes to me and tells his part of the story, I listen to the entire story. There will be a lot of emotion involved with it, but I use my mind to understand the story of the client. And I simply, after listening to the entire story of the client, I will simply ask him only one thing. What is the evidence he has? Now I'll pick the facts from the entire story and edit it. Now the purpose of an advocate is he can edit the facts. A competent advocate can edit the fact and trim the story necessary to get relief from the court based on the evidence he has. You could have 100 facts, but you could have the evidence of only 2 to 3 facts. So it is not necessary to plead the entire 100 facts. So there the talent of an advocate comes. This I will have to make a separate video with an example how 100 facts are pleaded, but 10 facts are necessary to prove a case. Not in this. So therefore the third aspect, the third element of a plaint, okay, the petition or the plaint is facts which describe that the plaintiff or the petitioner was robbed of his rights by the defendant or the respondent. That is the third aspect, third element. The fourth element is the cause of action. Now, to bring an action in the court, there should be a cause. The date, the time, they all are a part of the cause of action. That will be the fourth aspect. Because you can't bring a case which is where the cause of action is 10 years old to the court today. You give money to somebody else and 10 years you keep quiet. So the cause of action occurred 10 years ago and you come to court after 10 years for recovery of money. If it is for recovery of money, it is only 3 years. Then court will throw the case in the dustbin. It will not even allow it to enter the court. So the cause of action is very important. The date, time, the cause. That will be the fourth element of a plaint. The fifth element will be limitation. As I said earlier in the cause of action cause of action element, limitation will decide, because court can't wait for a cause of action to survive forever. There's a time bound for every cause of action to be brought to the court. You can't bring a cause of action which is 10 years old to the court for a recovery of money case. Court can't wait, because new rights develop when you ignore your right. When you sleep on your rights, new rights develop. So therefore limitation will decide the survival, the life cycle of a cause of action. So the limitation is the fifth aspect. And the sixth aspect is the valuation of your case. Every case has a value. Every case has a value. You can't have an unlimited value for a case. There will be some numerical value. So that will be the sixth aspect of the case. The seventh aspect will be court fee. Based on that value, you have to pay the court fee. And the eighth aspect will be the pecuniary jurisdiction. So based on the value, whether the case has to be filed in a mandal court, district court, that will be decided. The ninth will be territorial jurisdiction, where the case can be filed. You cannot file a case where the cause of action occurred in place A. You can't file in place B. You have to file it in place A itself. So territorial jurisdiction is the boundary in which the court operates. So that will be the ninth element of a plaint. And the 10th is prayer. So what is the relief that you are seeking? That will be the 10th element. So plaintiff details, defendant details, brief facts of the case, cause of action, limitation, valuation of the case, court fee of the case, pecuniary jurisdiction, territorial jurisdiction, and prayer. If these 10 elements are not there, then court will throw your case out of the court. You will not even have an entry in the court. Okay, thank you. Thanks for watching. Bye-bye.